For me, yes.
I don't know. It's very, it's a very because if he was it's the one thing that I always should have all the time, especially with I don't know.
These days, you got us so. Those are the back of the
Over on the left.
At the same time, you guys help me out all the time. You know what I mean? It's like I was running into any of you guys. Almost anybody in the field, too. Remember that? Install that camera. Install that camera. That's fun. You think that would kill somebody's career?
Yes. I'll let you know.
I'm breaking this. All right, Jared. I'll see you later, man. All right. I'm going to go this way. Watch your back. I'm going to go this way. Okay? Thank you.
Sure, everybody knows who was remanded.
What was the bail ask?
We asked for remand. His attorney asked for remand. His attorney asked for $1 million. The judge said she believed he was. Yep. You guys pass these back.
You have to give up his passport.
Well, I mean, he's in jail, so I think we actually do have it already. Yeah. Until his next court date is May 20th. The next step is cancel.
Okay, here comes Proffman, here comes Proffman. It's up, it's up.
Wait.
Don't everybody run, you have people on ladders.
Calling in docket 2011 NY 0P5773. Dominique Strauss-Kahn. Step up, Mr. Kahn. Stand right here and take the judge, please. This defendant is charged with criminal sexual acts in the first degree, attempted rape in the first degree, sexual abuse in the first degree, unlawful imprisonment in the second degree, sexual abuse in the third degree, and forcible touching. Pre-sworn affidavit is signed, waiving of the charges but not the rights to the record, counsel.
Yes.
Good afternoon, counsel. Can you please put your appearance on the record?
Benjamin Brathman and Associates, 767 3rd Avenue, New York. Joining me in the well of the court is William Taylor, who is not admitted in New York, but is counsel in this matter.
All right, thank you. Good afternoon, Mr. Brathman.
Good afternoon, people. Please put your appearance on the record.
Yes, for the people, John A. McConnell and Daniel Alonso. Good morning, Judge.
All right, people.
Your Honor, the people are serving felony grand jury notice and reserving statement and identification notice at this time. People are requesting that the court remand the defendant without bail. Your Honor, in consideration of the factors that are set forth in Criminal Procedure Law, Section 51030, subsection 2A, which I will discuss more for remand the defendant and hold him without bail. While the information that I will set forth about the defendant's background is preliminary, this is in fact one of the reasons why we feel at this time. Obviously, the case is relatively new in our investigation, not only of the case itself, but of the defendant are at a very early stage, and we are obtaining additional information on a daily basis regarding his conduct and background. Some of this information includes reports that he has in fact engaged in conduct similar to the conduct alleged in this complaint on at least one other occasion, and we are attempting to verify all of this, which certainly will take some time. The defendant up until recently was the head of the International Monetary Fund. He is a politician from France, an international figure. As a result, he's a man of tremendous and indeed global political and economic influence. And by all accounts, he's someone with access to substantial financial resources. He does not live in New York or even in the United States. He does not extradite his national in the United States. I'll address the extradition issues in more detail a little bit later, but suffice to say that it is in our view that if he went to France, we would have no legal mechanisms that would guarantee his return to this country to face these charges.
Before you continue, may I inquire, what is the prior occasion that you were or something?
No, that was before.
Thank you. May continue.
In this case, Judge, the proof against the defendant, into detail, he has almost no incentive to stay in this country and every incentive and resource with which to leave it. The people believe that the defendant will be able to make almost any amount of bail, and even millions of dollars would be a small price for him to pay for his freedom and the chance to avoid prosecution for his crimes. Therefore, at this time, we are requesting that he be remanded. We've been made aware that the defense has attempted to put together a bail package, and of course, we will review any package, but that review will take time and considerable resources to verify the underlyings of such a package. So with respect to the factors in the CPL, I'd like to speak a bit about what we know about the case. With respect to the conduct that is alleged, the charges here in the underlying conduct are severe, as are the potential sentences that the defendant could face should he be convicted. And these factors alone, the people believe, make remand appropriate. The defendant restrained a hotel employee inside of his room. He sexually assaulted her and attempted to forcibly rape her. When he was unsuccessful, he forced her to perform oral sex on him. As a result, he's charged with 2 counts of criminal sexual act in the first degree, which is a Class B violent felony offense, 1 count of attempted rape in the first degree, which is a Class C violent felony, 1 count of sexual abuse in the first degree, which is a D violent felony, and 3 misdemeanor sex crime offenses. If convicted, he faces substantial prison time on each of these. As I mentioned, a maximum of 25 years on the B violent felony, a maximum of 15 years on the C violent, and a maximum of 7 years on the D violent felony offense. And because of the nature of the crimes, he would be, there is the potential for consecutive time for each distinct criminal act that he committed. And as I mentioned, these factors alone give the defendant substantial incentive to flee. Second, the evidence that's already been developed against the defendant supports our request for remand. The victim provides a very powerful and deep committed by the defendant, which established all of the necessary elements of the crimes that he's charged with. She made outcries to multiple witnesses immediately after the incident, both to forensic examination and the observations and findings during that exam corroborate her account. The crime scene unit from the New York Police Department also processed the hotel room, and while those results are not back yet, preliminary indications are that there may be forensic evidence that will support the victim's version of events. While we're reserving formal identification notice at this time, the court should consider that the defendant was identified in a lineup within 24 hours of the incident. Given the strength of the case as it now stands and the potential for additional evidence to be generated, the defendant has additional motivation to flee. We also know that the defendant has the personal, political, and financial resources to in fact flee and evade law enforcement. He is a person of means, sophistication. By all appearances, he has the resources to evade capture and prosecution were he to be released. He has an extensive network of contacts throughout the world that can and likely would assist him. As I mentioned, he is a French national. He has sought political office in France, and he has significant long-term ties to that country while virtually having no ties to not only New York, but the United States. And any ties that he does have are outside of the county and state of New York. And certainly his ability to leave the country was demonstrated by the manner in which he left the hotel after the incident. But the defendant exiting the hotel through the lobby minutes after the incident would state that he appears to be a man who was in a hurry. Most importantly, if he were to flee to France or numerous other venues outside of this jurisdiction, we simply could not legally compel him to return. There is no mandatory extradition agreement in place between the United States and France, and they simply do not extradite their nationals. Even hypothetically, if the defendant's lack of ties to the jurisdiction and the powerful means and incentive that he has to flee, the people believe fully justifies our request for remand. It's also the things that, however, we don't know about the defendant and his resources at this time that should be considered by the court because they further support our request that he be remanded. About his finances, except to say that they appear to be substantial. We know nothing of how many bank and brokerage accounts this defendant has at his disposal or where those accounts are located. We don't know what other kinds of investments or assets he has, both liquid and illiquid, that he could call upon. And while we have done our own investigation and representation, how many or what kind of passports and diplomatic travel documents the defendant has. What is absolutely clear at this point is that the defendant really is in his escape from the jurisdiction, but also continue a life for himself in parts of the world that would place him beyond the reach of this state and indeed the country.
All right, thank you, Mr. Bratt.
Yes, Your Honor, if we accept the people's position, then as a practical matter, no successful individual who is a citizen of another country could ever get bail unless the district attorney's office was absolutely convinced of everything that they want to be convinced of, which would take a month or 6 months while the defendant is remanded. This gentleman is entitled to bail. He has no criminal record. He is 62 years old. He has 4 children, and they are simply wrong with respect to his ties to the city of New York and to the United States, and they're simply wrong. He has a daughter who lives in Manhattan. He is prepared to stay with her with the understanding that that he not leave New York City during the pendency of these proceedings. With respect to himself and his wife, they own a home in Georgetown in Washington, D.C., and to the extent that the defendant is a well-known, well-respected, international person, he is also probably the most easily identified individual in the world today as a result of publicity that has been generated during the past 72 hours. I also would add, for the benefit of the defendant, that he denies these charges, that he is presumed innocent under the law, something which I did not hear at all coming from the people's position, and he is presumed innocent, and indeed this is a very defensible case. There are significant issues that we have already found simply with preliminary investigation, and in our judgment makes it quite likely that he might ultimately be exonerated.